Marriage green cards in 2025, faster but riskier than ever. Marriage-based green cards remain one of the most common immigration paths. In 2025, new developments are changing how quickly applications are processed and how risks are handled. Many couples are seeing faster approvals than ever before. But with those approvals comes an equal rise in denials and far greater consequences for applicants who are unprepared. This video explains why the marriage-based green card process feels different today. We'll explore the opportunities, the risks, and the serious implications for families navigating these changes. Faster processing times. For years, marriage-based green card applications were associated with long waiting periods. Couples routinely waited 12 to 24 months before even reaching an interview. Today, reports show a striking shift. USCIS is moving marriage cases forward at an unprecedented pace. Some applicants are receiving interview dates in as little as 3 months. This acceleration is reshaping expectations. Families that once braced for delays now find themselves surprised by how quickly their cases are being scheduled. The timeline is not what it once was. While this change feels positive, the reasons behind it may be more complicated. Faster approvals are not necessarily designed to benefit immigrants or reduce stress for families. The political context. The Trump administration has emphasized stronger enforcement and higher deportation numbers. Faster case processing appears to align with this broader strategy in an unexpected way. When cases are processed quickly, approvals arrive faster, but so do denials. Each denial now typically results in a direct referral to immigration court through a notice to appear. By moving cases more quickly, USCIS can generate more denials, which then feed directly into removal proceedings. This allows the administration to report stronger enforcement outcomes. Applicants may appreciate shorter timelines, but the underlying motivation may not be immigrant-friendly. It reflects a strategy that prioritizes enforcement while creating risks for vulnerable families. The good news for families. Not everything in this shift is negative. Many couples with clear eligibility are benefiting from the new pace. Strong cases are now being approved more efficiently. This change provides much-needed relief for families separated by status concerns. It allows immigrant spouses to gain lawful permanent residence without years of anxiety or uncertainty. Applicants who overstayed visas are also benefiting. Instead of waiting indefinitely, they are securing lawful status and work authorization more quickly, offering real stability in their daily lives. For families with solid evidence of a genuine marriage, this acceleration can feel like a breakthrough. It demonstrates that efficient approvals are possible when USCIS prioritizes speed. The downside of speed. The risks are greatest for couples whose cases are less prepared. New marriages often lack extensive evidence, such as joint accounts, leases, or travel records. Historically, long timelines gave couples more opportunity to build evidence. Today, quick interviews leave many families walking into appointments without sufficient documentation of their shared lives. That lack of evidence can easily lead to denial. And in 2025, denial carries consequences far beyond a simple rejection. It often initiates removal proceedings in immigration court. This environment makes preparation more critical than ever. Couples must understand that speed does not replace the need for strong evidence. If anything, it increases the stakes. Pending applications no longer a shield. In the past, immigrants with pending green card applications felt somewhat protected. If they encountered ICE, pending paperwork could help demonstrate efforts to secure lawful status. Recent reports suggest that protection is far less reliable. Some immigrants with pending cases have still been detained, particularly in situations involving visa overstays or enforcement actions. This represents a major shift in practice. A pending application no longer guarantees safety from enforcement. Applicants must remain aware that their cases do not shield them completely. The new reality highlights the growing risk environment. Even while awaiting approval, families may face encounters with enforcement that disrupt lives and create financial and legal stress. Consequences of denial. A green card denial in 2025 often leads directly to a notice to appear in immigration court. The financial and emotional costs of this process are enormous. Applicants must often refile their case in court, paying new fees on top of the original filing fee. Court processing adds layers of complexity and delay. Attorney representation becomes nearly unavoidable in removal proceedings. Fees for defense can reach into the thousands, leaving families with heavy financial burdens alongside the fear of deportation. The risk calculation has changed. Where once a denial meant delay, today it can mean a pathway directly into removal. Families must approach the process with full awareness. Requests for evidence. Requests for evidence, known as RFEs, are also carrying heavier weight. These notices ask applicants to provide additional documentation to resolve perceived weaknesses in their case. The challenge in 2025 is that many RFEs are vague or boilerplate. Applicants may not understand the exact issue, making it difficult to respond accurately. If a response fails to satisfy USCIS, denials now follow more quickly. Second opportunities are rarely offered. A single misstep can shift a case from approval to removal court. Couples must take RFEs seriously. Treating them as routine requests can be dangerous. The consequences of an inadequate response are more severe than ever before. The question of intent. Non-immigrant intent is another area of concern. When individuals enter the United States on temporary visas, they are expected to leave. Applying for permanent residence too soon creates suspicion. USCIS often references the 90-day rule. If someone applies for a green card within 90 days of entering, officials may allege they misrepresented their intentions. This issue can lead to accusations of fraud. While not every officer applies the rule strictly, the risk remains real. Applicants must be prepared to explain their timeline clearly. Fraud allegations are serious. They not only jeopardize the current application but can create lasting consequences for future immigration benefits. Understanding this risk is essential before filing quickly. Financial barriers. Another area receiving increased scrutiny is financial eligibility. USCIS examines affidavits of support carefully, looking for assurance that the immigrant spouse will not become a public charge. Household income requirements must be met with strong evidence. In cases where families fall short, joint sponsors may be required. Weak financial documentation is now more likely to trigger denials. This adds another challenge for families already facing economic strain. Denials based on financial concerns carry the same consequence: potential referral to removal proceedings in court. Applicants must ensure financial paperwork is clear and complete. In today's climate, small gaps or unclear evidence can produce disproportionately severe outcomes for families. What families should expect. Marriage-based green cards remain one of the most accessible immigration benefits. But in 2025, the process is defined by speed, risk, and high stakes. Applicants with strong cases will benefit from faster approvals. Those unprepared face greater danger of denial and costly court battles that disrupt lives and finances. The message is clear. Families cannot assume the process is routine. Every detail matters. Every document counts. Preparation is the best safeguard against painful consequences. Summary. Marriage-based green cards are moving faster than ever before. Approvals are quicker, but denials are harsher. Pending cases no longer guarantee protection from enforcement. Requests for evidence are critical and unforgiving. Financial issues and questions of intent are being used more aggressively to challenge cases. Families must prepare thoroughly, understanding both the benefits of speed and the dangers of denial. The stakes are higher than ever in 2025. If you liked this video, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching. See you in the next video.